Hello everyone. So in today's video, we are going to do a revision of the Sale of Goods Act Unit 1. And as I have already told you, I have divided the videos in unit wise so that you can refer to each unit for whichever you want to see the video. You don't have to look through the whole video. So today we are going to start with the first unit of Sale of Goods Act. When we say Sale of Goods Act, it talks about a contract of sale. So, what is a contract of sale? A contract of sale is a contract whereby the seller transfers or agrees to transfer. So, it includes both transfers or agrees to transfer. That means transfers means what? Ownership is transferred immediately, which is a sale. When we say agrees to transfer, means what? Ownership is transferred on a future date, which is agreement to sell. So transfers or agrees to transfer. What does he transfer or agree to transfer? The property in the goods. When I say property in the goods, it means what? Ownership of the goods. To whom? To the buyer. And what does the transfer take place for a price? So if I look at this definition, I get the essentials of a valid contract of sale. So what are these essentials? First, there must be two parties, buyer and seller. Who's a buyer who buys or agrees to buy? Who's a seller who sells or agrees to sell? Then again, there must be some transfer of then there must be transfer of some goods. There must be a price, and the monetary consideration must be price. And since it's a contract under the Indian Contract Act, all the essentials of a valid contract must be present. So now we are going to look into these essentials that we have. The first one is goods. And when I say goods, goods means any movable goods. But when I say movable, it includes both tangible or intangible, both, but does not include money and actionable claims. So money is not goods. And what is actionable claims? When someone owes you money and you have a right to sue that other person, this is known as an actionable claim. This is not considered as goods. Anything which is a part of the land, growing crops, grass, trees, are they considered as goods? Yes, provided I sever them from the land at the time of sale. If I sell them with the land, it's immovable property. But if I sell them detached from the land, then it's a sale of movable product. Then any stocks, shares, stocks, goodwill, water, trademark, everything, old rare coins, everything is considered as goods. But ship is not considered as goods. When we say goods, goods can be classified under three heads: existing, future, and contingent. Existing, I have the goods when I'm contracting to sell them. The goods which are in the possession of the seller at the time of contract. Future, I don't have these goods, but after the contract is made, I'm going to sell these goods. I'm sorry, I'm going to get these goods. If I'm a manufacturer, I'll manufacture. If I'm a producer, I'll produce it. And if I have to get it from someone, I'll procure it and sell. So they are not in the possession of the seller, but will be procured or produced or manufactured by him after the contract is made. What is contingent goods? I don't have these goods. I'm not even sure I'll get them or not. If I get them, I'll sell. If I don't, I'll not sell. So, goods, the acquisition of which by the buyer depends upon a contingency. By the seller, it will be, sorry. By the seller depends upon a contingency. That is an event which may or may not happen. Now, when we talk about existing goods can again be classified into specific, ascertain, and unascertain. What is the basic difference? I go to the shop and I say, I want this pen. It's specific. That means I'm identifying the goods. I'm pointing out the goods that I want. It is known as what? Specific. I go to the shop and I say, I want a surface metal body red color pen. I'm describing the goods. My branding is description. Description of the goods is always unascertain goods. When, as per my description, the goods are taken out, the goods are what? Ascertain. So, specific goods means I'm pointing out the goods, I'm identifying them. Unascertain means they are not identified or agreed. When unascertain goods are taken out as per their description, they become ascertain goods. I hope it's clear. Moving on to the next one, price. Price is the next essential and it is the monetary consideration. It is only money, not money's worth. When I say money's worth, it means what? It is in kind. And consideration in contract of sale must be in cash. However, it can be partly in cash and partly in kind. That is possible, but it cannot be entirely in kind. In a contract of sale, how is the price fixed? Can the parties between themselves fix the price of the goods? By the agreement, they can decide the price at which the buyer is ready to buy and the seller is ready to sell. That is known as buy agreement. It may happen that we have not fixed the price of the goods. And it may so happen that even though we have not fixed the price of the goods, we have mutual dealings with each other. And on the basis of these dealings, we have modes of fixing the price. Right? Like, for example, I always sell you the goods at 10% below the market price. So even if I don't fix the price of the goods, I'll sell you the goods at 10% below the market price. The next one, it can also be fixed by a third party who's basically a valuer. When the price is to be fixed by a third party, this becomes a contingent contract. If the third party, there are three things here, understand. First, if the third party refuses to fix the price, the contract is void. If the goods are delivered, either part or whole, okay, the goods which have been delivered, let's say partially delivered, so that it will be easier to understand. Let's say partially delivered. For the portion which has been delivered, and the third party refuses to fix the price. For the portion which has been delivered, the contract is valid and I must pay a reasonable price. For the portion which is not delivered, the contract is void. If due to the fault of the buyer or the seller, if due to the fault of the buyer or the seller, the price is not fixed, the third party is unable to fix the price, then in that case, the contract is void. The third party will not fix the price, but the party who was preventing shall compensate the other party. That means if the seller was preventing the third party from fixing, the seller must compensate the buyer. And one more thing, however, if in case no price is fixed at all, you cannot say the contract is void, you must pay a reasonable price there. Right? You cannot say the contract is void, there you must pay a reasonable price. The next one, delivery. What is delivery? Voluntary transfer of the possession of the goods. It is not statutory transfer, forced transfer. It's not just transfer, it's voluntary transfer. By choice, the transfer of goods takes place. There are three types of delivery. First is actual delivery, where I physically give the goods to you, right? Where I physically give the goods to you. The second one is symbolic delivery. I don't give you the goods, but I give you symbols using which you can take the goods. The third one is constructive delivery. There is no change. So when I say, sorry, symbolic, when I say symbols like keys, document of title, constructive delivery, there is no physical movement of goods. The goods are where they are. Just by mere acknowledgement, the delivery takes place. Right? Just by mere acknowledgement, the delivery takes place. So when, let's say, the goods are in the possession of the third party and he's holding the goods for the buyer and he acknowledges to the buyer that I have your goods, this is known as constructive delivery. The moment he acknowledges, it's constructive delivery. The last topic of this unit, destruction of subject matter. The last topic of this unit, destruction of subject matter. Just one second. Destruction of subject matter. If even before the contract is made, the goods are destroyed, doesn't matter which type of goods, the goods are destroyed. A wants to sell his horse to B, B agrees to purchase. Both A and B do not know that the horse is already dead. Can I call it as bilateral mistake about the existence? Yes. What happens? The contract is void ab initio. I tell you, I will sell you, I want to purchase this pen from you, you agree to sell. The contract says on a future date, the ownership will transfer. From today till that future date, in between, the goods are destroyed. Can any other goods be this goods? No. So if these goods are destroyed, the contract will become what? Void. The contract will become what? Void. This is not void ab initio, sorry, it's a void contract. The contract will become void. Supervening impossibility. I want to purchase this pen from you, you agree to sell. The contract says ownership of this pen will pass to me after 10 days. After 10 days, in between this 10 days, this pen is lost. No other pen can be this pen. The contract is void. It's a void contract. It's supervening impossibility. On the other hand, I just tell you, I want a surface metal body red color pen. You say, ma'am, I'll sell it to you. In 10 days, you will get the ownership. I agree. On the fourth day, your pens are stolen. Since I have not identified the goods, for me, every surface metal body pen is the same. So if not this, you can give me some other pen. It works for me. So in this case, even if the goods are destroyed, the contract would be what? Valid. Right? With this, we are done with the key topics of Unit 1. In the next video, I'll see you with Unit 2. Till then, happy learning and stay motivated. Thank you so much.